The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as the public records and freedom of information laws. The content may include adult themes, concepts, or language not suitable for all audiences. Viewer discretion is advised.
Inside, take a seat, let the stories feed your soul. Hear the echoes, find the patterns, every truth, each hidden role. From the bench to the whispers, where the gavel takes its toll. There's a rhythm in the verdict, echoes from the cubby hole. Echoes, echoes from the cubby hole, where justice swings and stories unfold.
Welcome everyone back to your favorite cubbyhole on the internet. It is the cubbyhole after dark because it's late. It is late for me. We should be halfway through a show by now if we were serious about any of this business, which sometimes we are, but sometimes it just takes me a goddamn long time to get anything put together like tonight, because some stuff has happened tonight. Well, and today. And that's why we're here, because more has happened. We can't help it. And as I start looking at other stuff, and Jeep Daddy's distracted me because, well, he's here too. He can't help himself. I've sucked him in so deep. He's just someone throw him some water wings. At least you're smiling.
Look, it just cracks me up that I'm here and you're like trying so desperately to prepare, and I'm sitting here talking about everything else on the planet, trying to distract you and upset.
And it's working.
The entire yes. And I'm delighted. I'm this brings me joy at this late hour, bringing the red light district to the cubbyhole.
Now, so does that make you chaotic neutral or something else for this venture?
I'm just here to distract, drink, and make snarky comments as I'm wont to do on this lovely channel.
Oh, I know, you can't help it. And we're also here tonight kind of late because, well, someone is busy on Friday. We were texting back and forth, as we're wont to do from time to time. And I was saying, well, maybe I should wait until Friday. We'll wait for a couple more things to happen, like an injunction hearing that's supposed to take place Friday. And then someone says, oh, I'm busy Friday. So I'm like, well, okay, maybe we'll do something tonight, because some things have happened and it's worth talking about. So would you like to tell everyone what you're... Never mind, you don't have to tell people what you're doing Friday. That's none of our business.
Oh, it's just a lovely little soiree. It's no big deal.
I like soirees.
They are, yes. Maybe there's room for a +1 if you're nice to me tonight.
I think I'm going to have to be busy in front of the camera myself. You go have fun. I'll cover what happens in the injunction that day, provided we get some information before the evening grows too late. We'll see.
We shall see.
Yeah, it's too close to tell right now. Other than I'm sure when he can, Hey Rob will hop on and talk about some things. I'm sure he will be the first to the punch because, well, it's his case, and he's certainly entitled if anybody is.
I would certainly hope so.
Wouldn't we though? We would certainly hope so. Long before that's the other. Oh, God. I was sitting here typing in Twitter and quickly loading the thumbnail while the intro is going. That's how much of a shit show it is tonight. And then I forgot that I was trying to bring up the other. What was the other thing I was going to bring up on the YouTubes? See, now I've forgotten. Oh, God damn it. This is what happens when you slap things together, folks. It just turns into a major shit show, just like Laura Owens. Oh,
this is why I like being the sidekick, because I don't have to do all that crap, and I can just be innocently working on my budget and trying to figure out training courses for a couple of months down the road for some off-roading things. And
if you tell me you're doing your taxes in the middle of a show, if you tell me you're sitting there doing your taxes, I'm going to be pissed. That's just rude.
Okay, Okay, I won't say that then.
Yeah, don't. Hi, Lauren. How you doing? Nice to see Lauren here. Yo. So.
All right. So who's drinking what bourbon tonight? Oh, wait, never mind. That's not this isn't bourbon talk hour? Okay, never mind.
Should I go away for 45 seconds so you can talk about your bourbon?
No. Please continue.
Hopefully I'm not glitching out today. I've made sure at least I got something right. The VPN is on standby. It's idling right now so as not to suck away my bandwidth.
I apparently need to go into the cubby hole and fix your internet and fix your computer and fix all your things. Jesus Christ.
I know. A Windows 11 update has been pissing me off in the last 24 hours, and I don't know what the hell's going on.
I've heard all about it.
Yes, he has, but the rest of you haven't. Those of you who have a PC and do this nonsense with StreamYard and stuff, and you can't find anything, it's like, oh God, my entire desktop with all the documents is gone. Oh God, I can't find any of my devices. And oh God, I can't get into any of my accounts. It's a goddamn nightmare. It's a good thing I didn't have a reason to hop on last night, or I would have been screwed. I spent the whole evening, 5 hours, I think it was, trying to figure out where everything disappeared to and buried under 5 layers of different folder subdirectories. It's just, please, Microsoft, stop screwing around and get your shit together.
Micro slop these days.
Yeah. I know. We should all just live in the Apple ecosystem.
Don't worry.
Pay 300% more for our devices and just call it good.
Yeah, and have them last 300% longer, but also not have Copilot trying to do all the things inside of the operating system. Okay,
I haven't busted my watch yet.
Mm-hmm. All right.
I haven't busted my watch yet, so there is still hope. By now, I've usually got a few scratches on a new watch, so we're holding together pretty well.
Well, that's good.
So far, so good.
And Danny, yes, there are lots of glitches. The Matrix is glitching, but so far, Echoes has not self-inflicted any problems with his internet connection.
Sometimes I go back just to kind of check on things and how they turned out, and I just groan because I have high standards. I have unreasonably high standards. I have unreasonably high standards on like a Kia budget, as Jeep Daddy knows all too well.
Famous last words.
He at least has a paycheck to back up some of his expensive habits.
Shall we go on about your high standards that are unusual, or shall we continue with your?
Well, I don't want to dox myself any more than you already have, so let's not go there.
Oh, fuck off! You've already doxed yourself plenty on here. Don't even try. Don't even.
Oh well. Maybe the only one who should be worrying about doxing themselves is this guy.
The fucking douche canoe.
Oh, and, God, the dipshit. He's back.
And the ire of the bankruptcy court that I think is about to come his way. And I don't like telling tales out of school, but I think what's happening here could also influence someone's attempt to appear for somebody in their injunction hearing. I think there could be objections raised all around because someone has opened the door, as the phrase goes, to a number of issues. And those of you
tisk.
Tisk. You interrupted me mid stumble there, and it just threw me off even more.
Yep. It's fine. You interrupt me all the time, so that's fine. I apparently turnabout is fair play. So.
Well, it is on this channel. I don't know about it anywhere else. It certainly was. It certainly was with Law and Lumber with Rob and Ian Runkle talking about the bankruptcy hearing. They went through all the audio, and I've listened to that so many times and giggled every time. I went, "Gosh, these guys are brilliant." And they revealed some things. So I highly recommend everybody who wants some lawyerly insight into what took place at the last debtor's exam with Dingus the douche canoe kind of, sitting on the pine pony, that being sitting in the dugout, not even B string, but C string. And what they said about him trying to get involved and what Laura Owens testified to and the sort of legal liability he has just been exposed to by his so-called client. It's delicious. It's delicious. It's at the end of their 4 hour, some minute live stream. I highly recommend you watch Law and Lumber with Ian Runkle talking about the bankruptcy hearing that just happened.
Thank you for revealing that it's a 4-hour stream, because now I have saved myself
Yes,
3.5 hours of my life.
And because he's a bigger channel than I am, he can lay things out in chapters. So I can't do that till I get to the 1K at the least, as I understand it. Okay. So hit those like and subscribe buttons. Hit that bell that's down that way somewhere. Hit all those things so that I can do stuff like that and just be a good host and partition out all of the nonsense post discussion. Because I need about 30 chapters. I know. I need about 30 chapters. Jeep Daddy rants, Jeep Daddy rants, Jeep Daddy digressions, Jeep Daddy rants. That's and then case file. That's about how it's going to look.
I'm value add.
Value added. Value added is a thing.
Yes.
You can't help yourself. It's okay. You could blame the booze, but you won't, because you would be insulting your bottle.
I do this stone cold sober too, just for the record.
Why would you want to do that?
Like,
I do for my own reasons, but you don't have those same excuses.
No, but
so why would you?
Rant. The rants are available without the bourbon. So never fear if there's ever an opportunity where it's a 1 p.m. where it's not socially acceptable to drink, except for brunches, which the gays are good at bringing excuses why to drink midday. But even sober Jeep Daddy will have plenty of rants and snark to deliver. It's just slightly lubricated with my my company.
Thank you to MD Thomas for putting the timestamp on when that is in the Law and Lumber Friday, where it talks about the Laura Owens bankruptcy hearing. Thank you so much for that. See, if I were halfway competent at this, I would have had an extra hour and a half to put all this together and have information like that for you in the comments below or the stream description. But no, we're until we get to 1,000. I would say until I get to 5,000, this is going to be a little fly by night. That's just the way it's going to be.
You're lucky you've got such a gracious audience, and I for one am grateful for the audience for sure. I appreciate all of you.
They're good peoples.
Yes, they are.
They are. Not all channels can say that about their audience, but I better not digress into what I've seen on other channels. So let's not go there either tonight. We'll be here for another 5 hours because some of what I see is just disgusting. And I just, my level of disdain just doesn't want to get my toes that dirty in some of those channels, but never mind. So let's go to this lovely little thing. Enough of the rambling preamble, as we often do. Let's go. Let's see. Come on. Add it to this. What? Remove other media? What are you doing now? Oh, this thing is just being silly to me. Okay, let's try that. There it goes.
Hey,
you've got to rub StreamYard the right way. Oh, StreamYard. Yeah. Oh, there we go.
So this is the After Dark edition of the.
This is After Dark.
So
you get what you pay for. It is After Dark. If I were to choose some colors, you know what? Because I'm definitely not on the ball today. Let's choose a proper color in the cubby hole for After Dark. Let's just do something. No, that's too pink. We need a little more here. Reddish. It looks pink. Why does it look pink? These cheap light fixtures, I swear. Maybe that way. Okay, a little more red light district. That's better.
You just need to get a big red lamp like what I have in my house, and you'll be fine.
I know. Well, see, then I'd need a table and a doily, and it would have to be like a prop in the background. Because it's just too pretty not to be,
Yeah. I see no problem with this.
Well, it goes very nicely on your Steinway. So there's that.
That's true.
You can't help it. But it is a little dowdy. I mean, for me, at least. But it works very well for what you have it on.
Famous last words from Echoes coming right out of his, lying gaping hole. But please let's.
I do not have any doilies under any table lamps, so stop.
You're not. Don't try and convince the audience, this poor audience that trusts you to bring this information, that you're not gaudy and ridiculous from time to time.
Oh, Danny's too sweet. I'll be honest, I have no delusions of grandeur. He laughs because I'm lying. We all have delusions of grandeur, right? I'm just realistic to realize I'm not going to be a Megan Fox. I'm not going to have 50,000 people. I'm okay with that. It's okay. Yeah. And I'm not on here because it's partly my job and I've got to make some income off of it like some others do. They are absolutely entitled to do that. Unlike David Gingrich, I'm not going to bust anyone's balls for actually being business successful on YouTube because Christ almighty, it's a job. It's a fucking job and a half. It's 2 jobs because you've got to do your own production work unless you've got the money to hire people to do it for you. You've got to do your video editing and your thumbnails, which I'm just lazy at because it takes time to argue with AI to get what you want out of it. If you want AI imagery, like so many do, it's work. It's work, folks. My God. That's why you're here, and that's why I'm in front of the camera with my slightly inebriated sidekick.
Oh, wait, what? No, wrong one.
Oh, my God. Is this queer eye for the YouTube guy? Not yet. Not yet. But there are some attractive queer guys out there. I'll just say. Law and Lumber, Rob is pretty handsome. So I'm just saying. There's others.
The detail that Echo left out when suggesting that I watch that channel earlier. I might have prioritized it over other YouTube channels, but
yeah.
C'est la vie.
There are some fine specimens talking about Laura Owens, and it's like, oh, talk to me more. Tell me more about Laura Owens. You know what? I don't have to get on my own stream tonight. I'll just watch you for a couple hours. It's like some of them haven't figured out what Mike Gravelin on Law Talk with Mike has figured out of, where go ahead and wear the lumberjack shirt, but just don't button it up. That's okay. Yeah. I'm good with that. I'm very good with that. That's, I won't lie. That's kind of what got me interested in Mike's channel. It's like, which way does his flag blow? Because he's showing off the chest on his channel. Like, oh, what's this?
Hey, look, and any time, like, you got me very interested in Omar with all of his talk about his underwear early, from some weeks past.
I blame that on Schnitzel, which if you watch that video, that stream, that was apparently a viewer's question, and Schnitzel read it to Omar. I don't know if that's true or not, but that's how it was framed.
At least. And
I was like, what else about Omar do we wish to know?
Well, if we're going to go down that path in the After Dark edition, I've got questions. But
some of those questions may be left unsaid, or maybe you'll have to ask Mrs. Omar.
Yeah, probably.
And she may not be willing to tell you. They do have kids, so mind your P's and Q's.
That means little, especially if Mrs. Omar. Yeah, I was very distracted by that comment. Thank you. But if Miss Omar is a wine connoisseur, then many secrets can be spilled over the tasting table.
I think Omar likes the smoky stuff out of glass bottles. He's talked about his.
Mrs. Omar.
Well, yeah, I don't know about Mrs. Omar. Sometimes she's sort of hiding off camera and they talk about it. So we're supposed to call Rob Wood Daddy, huh? I didn't know that. He does turn a mean pen on his wood lathe. So there are some things the two of us would share in common in regards to woodworking and tools, but never mind. Shh. Keep it to yourself.
Don't blame me for distracting you. You distracted yourself.
No, I'm just telling you not to reveal too much. All right, Jesus back to this document. Have we done enough yet? That's 20 minutes. Let's keep
20
going.
minutes. It's 20 minutes of
Now, unlike David Gingrich, the Douche Canoe,
the fucking Douche Canoe,
we can read a professional filing for once. Something written by the amazing Jennifer Giaimo. And it's very concise, 5 pages, excluding the signature page in service. So this is what happens. This is part 2 of David Gingrich's filing to. It's almost like the intervener filing, but it's in bankruptcy court, and he wants to file a leave of court for a limited appearance for 60 days, unless he feels like he wants to stay longer. But if it's too burdensome for him in discovery and providing stuff, then he doesn't want to be. I mean, it's ridiculous. And Rob and Ian Runkle rake him over the coals, as well as telling him he should be getting himself counsel right now after what was said in that last hearing. So not so good for David Gingrich in the legal minds of people who do, in fact, practice in the legal profession. And I'm not one of those, but they are. And again, It's worth the watch. And what else is worth the watch, folks, if you haven't also seen it, is Jack Fox of Never a Truer Word talking about the same hearing. And he takes some things and he analyzes them, and that's not surprising either, his results. So lots for you to watch, folks. Go check out our friends who are talking about this, because it's good. And when you have professionals, why would you not want to listen, right?
I mean,
It's rhetorical.
The smart minds are
No
out
need
there.
to answer. That was rhetorical.
No, I think, yeah,
Oh.
yeah. That's the second rhetorical
It
question.
is good to
you trapped
see
me
me,
with
isn't
tonight.
it? Sorry, wicked reference. Oh my goodness. Okay, so we have.
Okay, Kristen, let's go.
She is not the only queen who's played that role. Thank you very much. I did enjoy Megan Hilty, and Megan Hilty has ties to the locale. She was good. Megan's funny, and did you ever see that show with Megan Hilty and Kat McPhee called Smash? It was like a couple seasons on NBC.
That was with Deborah Messing as well. That was part of
Yes,
that.
Deborah Messing, Christian Borle, and who else? Leslie. I've forgotten his name. Yeah, there's a few people, and even Bernadette Peters.
Yeah, there's lots of cameos that showed up. But I only watched.
I've got the score to that somewhere in my collection.
Season of that, and I never really found the second season, and I sort of just.
It was a little less
brain decided
appealing.
to go a different direction.
It was a little less appealing. It started turning into sort of a Pasek and Paul-esque show, and I think people started to lose interest because it's like, this is getting weird and modern and not so interesting ways. They were trying to take sort of a hard left into, okay, and this is modern theater, but yeah, it didn't. I think it lost its momentum. Oh well,
it didn't. I mean, it didn't last much more than 2 seasons. I don't think. So.
No, 2. Yeah, it might have only been the 2 seasons. I can't remember. Yeah. Just I appreciate some of the original score and some of that stuff. Good stuff by Mark Scheinman. Good stuff. Let me be your star. Okay. The United States Trustee, UST. This is the United States Trustee's objection to the motion for leave to enter limited scope appearance. And I would dare say that Queen Jennifer, as some people are calling her, will say something like this in this filing.
I made David Gingras my bitch.
I made David Gingras my bitch. Yes, we got fresh clips, folks.
I
made David Gingras my bitch. I made David Gingras my bitch.
I love it. I love it. I've been busy tonight. See, folks, this is what I've been doing. I've been slicing up audio for the last 2 hours. And we've got some other good things.
And the court hereby orders the following. Fuck off.
The court hereby orders the following. Fuck off. That's a good one.
I love that.
And then some classics.
Love that.
And then some classics.
I have done nothing except get pregnant by the fucking bachelor.
We can't be without that one because that might be useful at some point. As might this one someday.
It's not like I've gone and killed somebody.
Yeah, well, we'll see.
We'll see.
We'll see. There's a first time for everything, isn't there? That's not an accusation.
Speculate on what
that's not an accusation. It's not speculation either, but you never know.
Yeah.
Unstable people in unstable states of mind do unstable things. It's just kind of basic psychology, really. Okay. How many more times can I do this tonight? Make this difficult on myself. Oh, God. Maybe I should have started with some sugar. The objection to motion by David Gingras from David Gingras. So we're objecting to David just waltzing in as he wants to do. The United States Trustee, UST, by and through the undersigned counsel. So we even brought in Eileen Lashinsky as counsel. Or, see, okay. All right. So Jennifer Giaimo's the trial attorney. And Eileen is the trustee. Okay, so I'm curious why we haven't heard questioning from the trustee. Interesting. My mind is fascinated because I don't recognize Eileen's name for some reason. I don't know why. Okay, anyhow.
From the
By and through undersigned
trustees,
counsel.
that's something totally different.
Yeah, she's the one who should be most directly involved in the trustee proceedings, or the debtor hearings. So it's this is why I don't practice law. Some of the procedural stuff just escapes me how that functions. So we have the trustee filing the objection to the motion for leave to enter limited scope appearance, docket number 37, filed by David S. Gingrich.
The fucking douche canoe.
And respectfully submits the following. Memorandum of Points and Authorities. Debtor Laura Owens, a.k.a. debtor, a.k.a. I'll go with it, filed her voluntary Chapter 7 bankruptcy petition, in this case on December 8, 25, docket number 1. Debtor filed her petition pro se, and no attorney has entered an appearance on her behalf, but he's waiting in the wings. He's showing up to hearings. He's probably texting her, okay, Laura, talk about this. Okay, don't talk about that, Laura. Okay, be polite in your answer, Laura. I would like to see the texts back and forth between Laura and David, because in my opinion, they're happening. And strangely enough, at the last hearing, she didn't have any of her paperwork, probably because she was at her sister's house. That's speculation. But she didn't have any of her paperwork with her, but she had her phone. And David was listening. They should have kicked him out. They should have.
Yes.
It wasn't an adversary proceeding. There are other things that came up. There were other accusations made. And there were other liabilities wagered. Things that exposed David Gingras in not good ways. That's what I learned from Law and Lumber and Ian Runkle yesterday and today. I just keep listening to it over and over. It's just epic, absolutely epic. When you have other lawyers taking a listen to cases like this and saying, David Gingras needs to get his own counsel before he gets into even more trouble. That's saying something. That's saying something.
A lot.
Yeah. Yeah. It did not go without notice from me listening to that several times, listening to that. I don't know. It's the whole length of the clip. They talk about it, and they interject their legal opinions and observances. And because Rob practices bankruptcy and family law, he's not just blowing smoke up people's asses like someone else is. It's good stuff. Good stuff. I highly recommend it. Let's see. And no attorney has appeared on her behalf. Well, he's trying, but it's not going to happen, I don't think. On February 9 of 26, debtor appeared and testified at a continued meeting of the creditors pursuant to bankruptcy code, blah, 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 blah. The UST briefly examined debtor under oath at the 341 meeting. I love it. They've got numbers for everything. During the examination, it became clear to the UST that a more extensive examination pursuant to federal rules, bankruptcy, blah, 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 would be necessary. Accordingly, after the 341 meeting concluded, the UST filed a motion to obtain documents and examine the debtor pursuant to Rule 2004, etc. The court granted the UST's Rule 2004 motion on February 12. See docket number 36. On the same date, Attorney Gingrich, the same day, of course it's the same day, probably like right after they get out of the meeting, they're all filing stuff. On the same date, Attorney Gingrich filed, or as other people called him on Jack Fox's thing, David Greenhouse. Everyone's getting his name wrong. David Greenhouse. So that's why I just sort of cheeky titled the thumbnail as I did, David Greenhouse. It's like, oh, that's funny. I'll use that for this one. Why not? Yeah. We're told that he gets pissed off because everyone gets his name wrong. Well, I don't care. That's his problem. That's why I put it in quotes, because it was quoted from somewhere else. Oh, let's see. On the same day, he filed a motion to enter limited scope appearance. The UST now objects to that motion for two essential reasons. I like it. See how concise and clean this is? One, the local rules strictly prohibit the limited scope appearance that Gingrich requests. And two, Gingrich is disqualified from representing the debtor based on conflict of interest. had to scrounge for that one really fast. Forgot to cue those up. The UST has no objection to debtor's retention of counsel. The UST only objects to the limited scope representation that Gingrich proposes. Roman numeral 1. There is no legal basis to disregard Local Rule 9010. That rule states as follows. An attorney who files a debtor's bankruptcy petition or who files a notice of appearance on debtor's behalf must represent the debtor in all matters other than adversary proceedings until the case is closed or the court enters an order approving withdrawal or substitution of counsel. Local rule, etc. The 2018 notes to this rule state that the court will enforce this obligation regardless of any limitation contained in any retention agreement between the attorney and debtor. Despite this firmly established rule, Gingrich asks the court to allow him to provide some italicized, some legal services to debtor on a pro bono basis, but not without any pre-established limits. Motion to appear docket 37 at 3. He seeks permission to represent the debtor for 60 days with the option to continue that representation in his sole discretion. Significantly, Gingrich will not unconditionally commit to representing the debtor for a full 60 days. Rather, Gingrich states, quote, if the amount of work required by additional discovery requests from the trustee or any creditors become excessive, well, maybe exhaustive works too, undersigned counsel may terminate his representation, end quote. Local rule was specifically designed to prevent the type, that's an important word, designed to prevent precisely the type of limited scope, quotes, representation that Gingrich is proposing. The reason underlying such a rule was best explained by the court in Arisier. It's a case. Lawyers cannot indiscriminately dismiss clients at their whim, or even if their clients don't pay on time. Lawyers are professionals that owe fiduciary duties to... Okay, I'll finish this, but I'm going to lose it. That owe fiduciary duties to their individual clients and must continue to represent them even if initially rosy predictions turn sour. AM Bar Association section of Litigation Handbook, Unlimited Scope, Legal Assistance, etc., 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 etc. David, fiduciary for Laura Owens? No, surely you jest.
I mean, that is an interesting way to phrase that is phrased, and I know that that's not the DOJ saying that is like out of it's being quoted out of this.
Very much so.
That's a really interesting way, like phraseology of and word choice there.
That's straight from the American Bar Association Bar Association Handbook.
Yeah,
from whence all state bars kind of derive all of their things, as I understand it. It may as well be gospel in that case.
Yeah, it's a standard bearer for
for all intents and purposes,
as a baseline to go for. Yeah, makes sense.
It's my opinion, and it seems to be the opinion of other professionals in the legal world, that he's only in this for himself, and he's only wants to get involved in the cases to cover his ass, not so much cover Laura's. That's their opinion. I'm sort of restating what I heard from Runkle and Rob. Hey, that's a good show name, Runkle and Rob. I love it. My mother liked that show, Runkle of the Bailey, or that was the name of it. It was a British show, which is funny because that's Ian's name, I guess, too. Or he's adopted it. Maybe it's not really his name. It's funny, though. That was the name of the guy on that British show. Who's kind of... who does he remind me of? What's his name that played Mr. Wilson in Dennis the Menace?
Oh, God.
I'm blanking. Crusty old man. I don't think he's alive anymore.
The live action?
Rumple. Thank you, Becca. Rumple of the Bailey is the name of the show. See, that's why I think Ian's charming. He adapted his name to the show. Presumptively. Rumple of the Bailey. That's it. Yeah. You know, there's so many Britishisms in my house. It's just crazy. Moreover, allowing Gingrich to enter a limited scope appearance will needlessly complicate the process of obtaining stipulations, exchanging documents, and communicating about various aspects of the debtor's case. For example, it appears that Gingrich's proposed limited scope appearance would not cover issues pertaining to adversary proceedings. The UST's investigation of the debtor is for the express purpose of a potential advisory proceeding under Code Section 727, as stated in the UST's Rule 2004 motion. Would Gingrich be responsible for stipulations pertaining to adversary proceeding deadlines? If not, would counsel for the UST be required to communicate directly with the debtor with respect to some but not all issues in this case? The confusion as to what Gingrich will be handling and for how long he will be appearing is too burdensome to justify the requested deviation from local rule, etc. Gingrich offers no compelling factual or legal basis to wholly disregard the firmly established local rule prohibiting limited scope appearances. Therefore, the court should reject Gingrich's request and hold that Gingrich must either enter a notice of appearance subject to local rule, etc., or not appear at all in this case.
Damn.
Oh, let's see. Jennifer Giaimo says Ian's name is actually Runkle, and he named his show in honor of Rumple of the Bailey. Well, yes, that makes perfectly good sense. Of course, it's ideal. If I had his name, I would have done the same damn thing. Walter Matthau, thank you. Thank you. Yes, Walter Matthau. I can't remember who played Rumple in the show, but I haven't seen that show in ages. It's a memory, a fairly strong memory, but I just don't remember details because I was young. That's a long time ago.
Yeah, it's a little bit.
I know. Don't remind you, right?
Yeah, thanks. You're just going to cause me to drink more.
I take no responsibilities for your ingestive habits.
Lies.
So Gingrich offers no compelling factual or legal basis to wholly disregard the firmly established local rule prohibiting limited scope. Did I reread this? I think I did. Or not appear at all. Okay, next paragraph. I should have scrolled while I was talking. 2, Roman numeral 2, Gingrich has a conflict of interest. And this is what Rob and Ian were talking about. Law and Lumber and Runkle were discussing on their last Friday thing. The conflicts that have been raised with Laura Owens throwing him under the bus. I don't know. Maybe Laura Owens is going to pull a Dave Neal and
I made David Gingrich my bitch.
Make him her bitch too. I don't know.
She sure is working on it.
She's trying. I don't know if she will succeed.
I don't know who's going to become a who's bitch. Maybe it's just going to be this weird.
It could be mutual bitches
of bitchiness.
Conjoined bitches.
Maybe it's just going to be like this vacuum.
Or is that too parasitic? You know, like parasites.
Well, they have a very parasitic relationship.
It sure seems that way to me.
At this point, it's just oh my god.
Yeah. Debtor's largest creditor in this case is Clayton Eckert. The debt owed to Eckert arises out of a paternity suit filed by debtor against Eckert in a state court in Maricopa County, Arizona. Quote, the paternity suit. During the course of the paternity suit, debtor testified under oath and filed a sworn affidavit regarding her financial condition and income. Oops. She's blown that one up a few times now, hasn't she?
I don't know. Again, I don't know how somebody can owe income tax for a particular year if you had zero income for a particular year, but please continue. Say more.
At the meeting of creditors in this case, debtor was questioned about a particular affidavit filed in the paternity suit in which debtor attested to owning a financial account with over $450,000 of funds. I would like to have that problem. That's a problem I would love to have, having an account with $450,000 in money. I love that.
There's a few musical instruments that exist out there that I would not have an account with $450,000 in it.
I don't know if I need to pay that. Well, no, I suppose there are some things I could.
At that point, I don't give a shit. If I've got that kind of dollars sitting in a bank account randomly, like, yeah.
In
certain
response,
7-foot instrument will be in my house. I don't give a shit what you think.
you don't need $450,000 for that.
I don't. I need about a tenth of that. But yeah, let's
Yeah,
continue.
well, in which case I'd have to come over to your house to get some work done. In response, debtor testified that Gingrich could explain the circumstances of that affidavit and offered to allow Gingrich to testify at the meeting of creditors. That's not good.
Well,
That's not good.
footnote.
That's not good. Footnote 1. The UST is in the process of obtaining the transcript of the 341 meeting. Okay. In light of the foregoing, Gingrich is a potential witness who, according to debtor's own sworn testimony, has personal knowledge of highly relevant information concerning debtor's sworn statements regarding debtor's assets and income. Yikes.
Swear to
Hashtag
God,
yikes.
I'm going to rip out my AirPods if you keep pushing that button.
There you go.
You're welcome. Thank you. Oh my God. That's crazy. Yeah. Mm-hmm. Go get him, DOJ.
Unquestionably. What is... Oh, God. What is going on? My Twitter is blowing up all of a sudden. Okay, never mind. Unquestionably, such information is material. Let me try that again. Unquestionably, comma. Take two. Such information is material to this bankruptcy case and directly bears upon two crucial issues. One, whether the debtor, in fact, had assets and income that have not been disclosed in this case. And two, whether the debtor made a false oath in this case or alternatively perjured herself in the paternity suit. Is there a possibility that all of the above are true?
Yeah, column C, all of the above.
Wow. Are we excluding anything for a reason? I don't know.
She says, let's go, honey. Let's go.
Half-ass fashion says harpsichord. No, I've already got one of those. Okay, never mind.
You do?
You know anyone who wants one? I could
Me?
sell that off.
I don't know.
You don't want a harpsichord. What would you do with it?
No, I don't. That's way too old world for me. I need something.
I know it's a little too flat earth for you, isn't it?
Yes, it is.
But just think how charming it would be playing Mozart on it.
I can do that just fine on my Steinway. Thank you very much.
Yeah.
Or my future Steinway B, but hey, whatever. Okay, it's fine.
You could sell a truck and go buy it, but never mind.
No. Don't even. No.
Is that too much temptation? Good.
No. I'm going to roll up a newspaper. I'm going to whack you upside the nose the next time you suggest.
I get a bitch slap me through the camera.
Yes.
That's harassment. I'm filing an injunction of harassment.
Oh my God, it's harassment. Oh
he's going to bitch slap me through the camera or through the phone. How can anyone take a statement like that as a credible threat of any kind?
Yeah.
Rule 3.7 of the Arizona Rules of Professional Conduct, which applies to attorneys appearing in this court pursuant to Local Rule 9010-1A, prohibits a lawyer from acting as an advocate for a client in a case in which the lawyer is likely to be a necessary witness. I wonder if you ever thought that would... And he's already a witness in her criminal trial. Oh, you can't make this stuff up, folks. In light of Gingrich's knowledge of debtor's sworn statements pertaining to her income and assets in connection with the paternity suit, Gingrich is a potential witness and therefore disqualified from representing the debtor in this bankruptcy case. Footnote 2 at the bottom.
Footnote.
The lawyer may act as an advocate despite being a potential witness only if 1. The testimony relates to an uncontested issue. 2. The testimony relates to the nature and value of legal services rendered in the case. Or 3. Disqualification of the lawyer would work substantial hardship on the client. See Rule 3.7 of Arizona Rules of Professional Conduct. Final page. Wherefore, the UST requests that the court sustain this objection and deny the motion to appear. Submitted 17th of February of 26 by Eileen J. Lashinsky. Jennifer A. Giaimo, trial attorney. There you go. Certified foregoing pleading was served on the following Laura Owens and David Gingras. Oh, so it's already been serviced, as one would expect.
Wait,
There's
where's
that
all
little.
all the pictures? Where's all the
Where's all the color
examples
pictures
where's the
of Laura in
rhetorical-
like spandex standing next to a horse?
Where's all the rhetorical questions?
Look at my
and,
keybacker
like,
titty shirt.
snarky, yeah, like all of that. Like, where's all that? Oh my god.
Where's Clayton Eckert's picture? She was made pregnant by The Bachelor, even though the court said otherwise.
I can't handle it. Oh my god! Like this was The Bachelor. Like as nobody knows. Oh my
Get
god.
pregnant by the fucking bachelor.
Yeah. Okay.
Yeah.
Yeah.
Yeah. And then there's this other thing. Should we do this other thing? Do we dare? Should we? You know what? Maybe I could put it at like 1.5 speed and see what happens. Should I try that?
Hey, we're only at 46 minutes. If we end now, this is like our world's record.
It's got to be a record
show. So
it's got to be a record.
Yeah.
I mean, everything else is just going to be me trying to legally speculate, which I probably shouldn't do, even though I sometimes do that because, well, it's my show and I want to speculate.
Yeah,
and I
do
can.
what you want.
I mean, even as a lay person, I can speculate, even though I don't know shit.
You are entitled to your opinion, and your
I am
perspective
entitled to
is
my
provided
opinion.
by the First Amendment and
As provided by the
use
First Amendment.
free use and fair something or other, whatever you said in your intro.
All of that stuff in the beginning, yeah. So then there's this thing that landed this evening. I was getting distracted. I love it. That's actually a good AI of her. Woo! Laura, behold your future is what I want to caption this. If I were the artist. If I were the artist, I would say this is Laura's future. Well, her future's not going to be suing a brother for probate, but
yeah, maybe not. But.
No, and I believe, if I'm not mistaken, Big Tiff is going to talk about this, I think, tomorrow. So I'm not trying to beat anyone to the punch, but I happen to see it, and I'm on, and it's pulled up. So I'm curious about this hearing of the probate.
I mean, if it's here already, let's I don't know. 1x,
and we're going to put it at 1.5
2,
speed. Let's see what happens. If it gets
yeah.
obnoxious, I'll slow it down. Okay. I know the outcome of this.
I mean, given who this is,
we talked about the outcome of this.
It's
Mama Owens was denied. She was shut down. We read the dismissal by the probate court. So that was it 2 episodes ago? This is just sort of the cherry on top of the money grab from more crazy Owens women. I'm still convinced, and again, it's my opinion. Mama's not playing with a full deck either. It's my opinion, but I think that's true.
2011-00653. This is in the matter of
Ooh,
the
it's
probate estate of
unbalanced
Elizabeth
audio. Sorry,
Williams
I didn't
Naylor. Again, my
record
name
it.
is Judge Josh
Rude.
Allison. Thank you all for being here today.
It's right channel
First
ID.
thing we're going to do is have you all who want to tell me who you are for our record, so we have a record of your appearance. There's no one here in the courtroom other than my bailiff and our court monitor. If that changes for any reason, I'll be sure to let you all know. Why don't we start with counsel for the personal representatives, please?
Yes, Your Honor, it's Vaughn Thomas.
Oh,
I
wow,
am
it's in
counsel
stereo.
for the personal representative
Left channel heavy.
and for the co-trustees of the decedent's
Oh,
trust.
good. I'm getting it in
Thank
2
you very much,
channels.
Mr. Thomas. All right. Do we have Elizabeth Ann Naylor Owens? Are you here?
Yes, I am, Your Honor.
AKA Jan
Your
Black.
screen says Jan Black. Do you
Jan Black is my professional name. Elizabeth Ann Naylor Owens is my legal name.
All right, thank you very much. All right, who else do we have here?
Jan Black is my professional name.
Is that is that your professional name in like one of those like late evening businesses sort of thing, honey?
It's like my stripper name. Okay. My professional name.
Jesus Christ.
I know that's what she's used because she keeps saying, well, there was Elizabeth Taylor and I don't want to be confused with the actress. Oh, please. Like anyone's going to confuse you with someone on the screen.
Yeah, totally confusing. Yeah.
I think there's more to this story, and I think it's a story she doesn't want people to necessarily know. But that's just my opinion. Okay, sorry, I can't help it.
Needs to enter an appearance, you're welcome to do so now, please.
Your Honor, Theo Offerstig on behalf of Guy Markley Naylor and Dale W. Gunn.
Thank you very much, counsel. All right.
I'm glad I've
Anyone else
sped
who
it
needs
up.
to enter an appearance today? Okay, hearing none, thank you. All right, I've got two motions set for our hearing today, which has been vacated and reset a number of times. The motions I have set for hearing are the petition to withdraw as counsel and to substitute counsel, and then also the motion to dismiss. I would propose that we hear the motion to dismiss first, unless folks think that's a bad idea, in which case I'd entertain hearing the motion to substitute first. Doesn't really matter to me, but it just seems to make sense to me to do it that way. Anybody have strong opinions one way or another?
Your Honor, I was under the understanding that this was the motion to reopen probate, that was initially what I had requested of the court, was the motion to reopen it, and the motion to dismiss, I think, was filed after I had requested the motion to reopen it.
Is that too fast?
Yeah, I'm sure that's true that the motion to dismiss was filed after your motion to reopen was filed.
Not to me.
But the November 17, 2025 notice of hearing that was sent to everyone lists two motions. It's the motion to withdraw and the motion to dismiss. Naturally, the motion to reopen will be part of the discussion, but it is not separately set for hearing today. I probably couldn't tell you why without spending a considerable amount of time with the docket. What I can say, just to cut to the chase, is that if we didn't get a notice of hearing and a proposed notice after the resets and the number of vacatings of the hearings, it wouldn't have been reset. But I'm happy to hear from all of you about why the petition should go forward. That's essentially what the motion to dismiss is arguing anyway. Okay?
Okay.
Thank you.
Your Honor, may I interject? This is Vaughn Thomas. I don't know whether my profile can be seen visually. Not that matters, I presume.
I can see you when you're speaking, and I can hear you.
Very good. I don't need to see myself.
All right.
Your Honor.
In any case, I have no objection to the court hearing the motion to dismiss first, and Mr. Offerstig is prepared to do that, I believe, Theo.
Yes, I am. We also have no objection to hearing the motion to dismiss first. If there was an affirmative decision on the motion, it would moot the petition anyways.
All right. Well, let's do this. We'll hear the motion to dismiss, which naturally takes issue with the motion to reopen and the petition. So I've read the motion to dismiss. I've spent some considerable time with this docket, believe it or not, and I've read the motion to reopen and the claims that would be sought to be made in this case. So I think I'm pretty well up to speed. What I'd like to do is to hear from counsel on the motion to dismiss. Then we will hear from would you like me to call you Ms. Black or Ms. Naylor? What's the best way to address you?
Well, for purposes of this, Elizabeth Naylor Owens is fine. You can call me Elizabeth. I'm named after my mother, whose estate this is all about.
Legal name.
We'll use our real name, or is it personality A or personality B? Which one of the split personalities are we using at any time? Today I'm Jan Black. Tomorrow I might be Elizabeth. What is going on here?
Whatever suits me best.
Whatever gets me out of any legal trouble is probably the answer.
Right. Yeah.
Although, when you use multiple names, just like someone else in Florida is using multiple names depending on their mood. Lynette, Michelle, Lacey, Alexis, Ruby, Preston, LMNOP, et cetera, et cetera, et cetera, et cetera, et cetera. These are not normal people.
Naylor Owens, okay? Is that all right?
That's fine.
Okay.
Whatever. Thank you, Judge.
We'll go with that. Okay, thank you.
I appreciate it.
So we'll hear first from counsel who's making the motion, then we'll hear from Ms. Naylor Owens, and then I'll have some questions about what's being pled here along the way, and then we'll go from there. Okay, thank you. Counsel, please go ahead.
Thank you, Your Honor. So to put it simply, today we're asking the court to dismiss Ms. Owens' petition to reopen probate and to also close this probate matter. All of the assets, which was just all the estate assets, which was a Raymond James account, was already transferred to the trust. Any other assets were transferred to the trust prior to the decedent's death, so that would be the decedent's primary residence and any personal property. There was a Bank of America account, but that was set as a transfer on death to Guy Markley Naylor, who I refer to as Mark, and will refer to him as Mark throughout the rest of my argument. So there are no estate assets for this court to probate. And then in Ms. Owens' petition, she doesn't challenge any testamentary instruments. She's not challenging any testamentary instruments, and there are no assets left to probate. If she also requests an accounting from the estate and the trust, all of those issues and the other issues raised in her petition were already fully resolved in the non-judicial settlement agreement. As far as we see it, there are no matters remaining for this court to hear. And with that, I'll yield
But
to
I
any
want my
questions.
money anyhow. Give me the money. I know
Yeah,
you're
oh my
hiding
God,
it,
I want it
Dan.
all.
I know you're hiding it, Mark. I want my money.
The court.
Thank you
That's what
very
this
much.
is
I guess
about.
my starting question for you, counsel, is what, you know the estate better than me, obviously. You've spent time with it. I have spent limited time with it comparatively, of course. If put yourself in my shoes for a second, if Ms. Naylor Owens were to succeed, prevail in any of her claims in her petition, would those impact the estate at all?
Well, to answer your question, it's difficult to discern based on the petition what exactly she's requesting. I think the petition misunderstands the difference between a trust estate and a decedent's estate and probate. I mean, there's the settlement agreement, and I'd like to just point this out to you if you haven't seen it already. Waives the preparation, audit, and confirmation
I
of further
want to
details.
say to Jen's comment, she's digging in an empty mine is what it's. She's digging in as empty mine as Laura's womb is non-fertile with twins. Sorry, I couldn't sit on that one.
That is fair. But also,
Yeah. Well, there have never been any babies, so let's just call it what it is.
let's just call it, yeah. Spade is a spade.
And until there are babies, what do you do?
Count by any court, and I'm referring to the motion to dismisses
Exhibit A?
Exhibit A. And then it's Exhibit A to Exhibit A, page 7. So, according to the settlement agreement, the parties waive the preparation, audit, and confirmation of a further detailed account by any court. They approve the statement of accounting attached as Exhibit A. They approve the administration of the estate and the 2011 trust. Approves the payment of indebtedness and special allocation of cash from the proceeds of the sale of residence on the 2011 trust. But I'm not going to go off reading each and every waiver in here. But
I mean, this is all
as far as we are concerned,
procedural stuff.
The settlement agreement was comprehensive and resolved every issue that Ms. Owens is asserting in her petition.
Where does the judge rule on being able to just dismiss or not? Is this the entirety of this?
At the end, I want to hear the whining from her is what I want to hear. I mean, these are competent lawyers saying there's nothing here, Judge. There's no here, and there's no there. So I mean, I probably could skip it, but this doesn't have things parceled out. So I think I'm just going to have to muddle through it until we get to her thing. But I want to do this and I want to do that. And I just want to see if she's as whiny as her daughter trying to demand things.
They're just, as we say in the introduction of our motion, there are simply no matters contained in the petition for this court to adjudicate.
Okay. All right. Thank you very much. And let me hear your name one more time, your last name, so I can try my best to pronounce it correctly.
Yes, it's Offridge Tig.
Offridge Tig. Okay. Thank you, Mr. Offridge Tig. All right. Why don't we hear from Ms. Naylor Owens, please? And I may have a few questions as we go along, but I'm happy to hear from you primarily about what you need to happen in the probate estate, which is the basis of the motion to dismiss. So thank you, Ms. Naylor Owens. Happy to hear from you.
All right, thank you so much. Well, obviously, I disagree with the contentions that were just made, and I do have, because it's a bit of a complicated situation, I do have a statement that I'd like to read that could perhaps clarify things a little bit better.
Sure.
She's going to talk.
Okay. All right. Well, Your Honor, I am asking the court to reopen probate because the estate of my mother, Elizabeth Williams Naylor, was never properly administered, and reopening probate is the legal mechanism designed to address exactly this particular kind of situation. Under New Mexico probate law and the New Mexico Uniform Trust Code, this court has the authority to reopen an estate when required acts were never performed, when assets were not distributed, when fiduciaries failed to...
ChatGPTs.
And I've been saying it forever, like mother, like daughter. 2 peas in a pod.
Yeah.
2 flies on shit. I don't know. Pick your analogy.
Count where beneficiaries were harmed by breaches of fiduciary duty. The facts of this case fall squarely within those grounds. And
this is a fair question. Did Gingrich help? I don't think so in this case, but we don't know. What?
I just noticed that in the chat, and I'm like,
I don't think so.
Maybe,
I don't think so, but we don't know. We're not there. Maybe, maybe not. If he did, well, woe be unto her as well as her daughter.
No shit.
If you're going to be stupid and get him involved in all of your life stuff, then you deserve what's coming.
Yeah.
No, Jen, we don't know. We don't know. Chat GP Jinky.
Nice.
Oh, you guys are funny.
I want to be clear at the outset here. I'm not contesting my mother's will or trust. I'm simply asking the court to address failures of administration.
I'm contesting I didn't get enough.
That occurred after her death. On May 24th, 2011, while my mother was gravely ill and lying in a hospital bed in Albuquerque, at the encouragement of my brother, Guy Markley Naylor, and his now husband, Dr. Dale Gunn, my mother executed a new last will and testament and a trust agreement establishing the Elizabeth Williams Naylor Protective Living Trust. This came as somewhat of a shock to me because for many years before that, my mother already had a will. It was simple, just a couple of pages. She kept it in the desk in her bedroom. She told me exactly where it was and told me that if anything happened to her, that was where I would find it. I understood that document to reflect her longstanding wishes. I was therefore stunned to learn that while she was seriously ill in the hospital, and in fact, I believe that Mr. Naylor and Dr. Gunn believed she was on her deathbed at that point, although she did not die for another 6 months. This new will and trust were prepared by F. Vaughn Thomas, who was the personal attorney for my brother and his now husband. And the will was presented to her at her hospital bed for execution. I was also troubled to learn that although the will and the trust were executed on the same day, they were not consistent. The trust divided the estate equally, 50-50, between my brother and me. The will, however, included a provision giving 5% of the estate to Dr. Gunn, who was not a child of my mother and who would later serve as co-trustee. I was also deeply disturbed to learn that the will contained a provision leaving $1 to anyone who contested it. There were only two beneficiaries under the trust, my brother and me. And my brother, as I mentioned, was also personal representative of the estate and co-trustee of the trust. That meant the $1 provision could really only realistically apply to me. That provision was not at all like something my mother would do. It did not reflect her character, and it certainly didn't seem like something she would ever have come up with on her own. The trust itself was explicit.
We're alleging skullduggery without actually saying it.
I mean, that is.
They got a new will and they passed a fat one under my mother and she signed it, and now I've been screwed out of it. So now I'm pissed and I want what's owed to me is what this is about.
It's kind of, definitely.
I knew it. This is sour grapes.
So
I'm entitled, goddammit.
You recall the hoarder house situation that I dealt with some years ago.
Yeah.
The provision in that will was also to say that the maximum that any claimant that was not provisioned in the will, like a stray relative or whatever that suddenly showed up out of the woodwork, was $1. And that's what they were entitled to. This is not unprecedented, you dumb bitch.
Yeah, it was right before she passed away. Elizabeth Williams Naylor. Yeah, 2011 was about the approximate date. So that seems accurate. Yeah.
Maybe her mom figured it out that she couldn't like
maybe she hates her daughter more than
Look, in my grandfather's estate, my dad was put in a trust, like his half of the estate was put in a trust because my grandfather knew damn well that he couldn't be trusted.
Yeah.
And so one side of that equation got everything 50-50 free and clear. The other side, that was locked up. So
South Florida makes the very salient point. She was singing a different tune when she borrowed $65K from her dear brother. Or more accurately, she borrowed tens of thousands, maybe 65 is the total, from the estate, from the trust. And she was going to them multiple times. I think I counted at least 3 iterations. Oh, we've been on some hard times. And, oh, Ron's going through a hard time with the radio station. We just need to borrow a little bit more money. Oh, we had some bills come due. Oh. I mean, she may as well have been standing on the street corner with a cardboard sign. The way she was going to her brother constantly to borrow money. Oh, we're homeless and destitute. Oh, please, Brother Mark, can we borrow more from the trust or estate or whatever?
Oh, the magnet is stuck in my palm and my forehead again. Oh, God.
They have been bad with money for decades. Big Tiff has covered that. Extensively has Big Tiff covered how poor, piss poor they have been with managing their money. And what I suspect is going to happen, not speaking of money, since this is about money really in the end, as well, it's assets, same thing. I would not be surprised if in the digging with Laura Owens and the debtor's exam and with the DOJ getting involved, if there isn't going to be some digging into things like mortgages and other loans that maybe were falsely applied for, maybe, perhaps, possibly.
Really? What? No.
Again, Law and Lumber, Rob and Ian Runkle talk about those possibilities and talk about what that could mean for them and what that could mean in terms of liability and prosecution. So again, I highly recommend you go visit Law and Lumber and listen to this a little bit more with what they do say. It'd be very interesting to, I don't know that Rob does probate stuff, but if he does bankruptcy, it's not a far cry. We're talking about assets and money and trust and things. I would think there's a little bit of crossover, legally speaking, but I don't know. I'd be curious what their take of the probate thing is.
And unambiguous. Upon my mother's death on November 21st, 2011, which happened to be Thanksgiving morning, more than 14 years ago, all trust assets were to be distributed outright and free of trust. There were no continuing restrictions, no discretionary delays, no authority to withhold distributions indefinitely. From that moment forward, Mr. Naylor and Dr. Gunn executed exclusive control over all estate and trust assets, and they owed fiduciary duties of loyalty, transparency, prudence, and impartiality to both beneficiaries. I trusted them. I trusted them to honor my mother. I trusted them to carry out her final wishes. I trusted them to protect my interests. It never occurred to me that they wouldn't, and yet they didn't. Your Honor, the co-trustees submitted a document to this court stating that the contents of my mother's home were somehow appraised on the very day she died, Thanksgiving Day, November 24th, 2011. She died that morning. That filing reflects immediate access to and control over the home and its contents. In fact, over the years, the co-trustees were able to remove and transport many items of my mother's personal property from her home in Albuquerque to their home in Santa Fe. Despite having the ability to move and control these assets, they took no steps whatsoever to send or deliver the personal property I am entitled to my home in Scottsdale. Yet despite that access and control, and despite the trust's requirement of prompt distribution, my share of the personal property has never been delivered to me more than 14 years later. No furniture, no artwork, no antiques, no personal effects. Instead, the co-trustees now claim that my share of the personal property is being held in a storage unit where they say it's been for approximately the last 3 years. Through their attorneys, though, they have refused to disclose the location of that storage unit, despite the fact that I had hired an attorney who was working on the case with me for a couple of years and repeatedly requested the location of the storage unit. They have refused to provide a complete inventory of what's in the storage unit, and they refuse to allow me to inspect or retrieve any of the property. I have no idea whether it's in Albuquerque or Santa Fe. I know it's not in Scottsdale. Despite this, they've insisted that I should pay the storage costs for this. The co-trustees, again, had the ability to move and distribute property when it suited them, but chose not to distribute my share. Under New Mexico probate and trust law, fiduciaries may not retain exclusive possession of estate assets for more than a decade while denying a beneficiary inventory access and delivery. This is really not a delay. It is a failure to perform a required act of administration. My mother had moved into assisted living approximately 1 year before her death, and from that point forward and continuing after her death in November 2011, the co-trustees allowed her home to remain unoccupied, unrented, and unsold until it was finally sold at my request in the spring of 2023. That was more than 12 years during which the estate's primary asset produced no income for the beneficiaries. That is especially significant because my mother's will expressly authorized the personal representatives to sell or lease the property immediately upon her death. Despite that, the co-trustees did neither. Instead, unbeknownst to me, Mr. Naylor and Dr. Gunn transferred title into their own names very soon after my mother's death, excluding me entirely. I was never informed of this, and I only learned about it years later, in fact, just a few years ago, when I applied for a loan and listed my interest in my mother's home as collateral. I was shocked when the lender told me there was no county record of my ownership interest, only that of Mr. Naylor and Dr. Gunn. During this entire period,
wait a minute.
Hang on.
We need to back that up a little bit.
Wow. Okay. Wow.
I think there's an admission here. Let me back up a few clicks and let's slow this down a titch. Were we using the trust as collateral to get loans? Were we? Is that what I just heard?
Extraordinarily interesting point that she brings up there.
I was never informed of this, and I only learned about it years later. In fact, just neither immediately upon her death. Despite that, the co-trustees did neither. Instead, unbeknownst to me, Mr. Naylor and Dr. Gunn transferred title into their own names very soon after my mother's death, excluding me entirely. Cool. I was never informed of this, and I only learned about it years.
Not sure it did.
Okay, you may not have, but my contention here is that Miss Elizabeth Jan, whatever the fuck she wants to be called this week, is under the impression that house sales happen overnight. Like, oh, somebody
Immediately.
dies on
It should
a
have been
day,
immediately put up
and
for
then
auction because I wanted the money.
Tomorrow it goes up like and suddenly gets sold the next day. Honey, this is
She wishes.
2023. Shit doesn't happen really fucking quick. And houses don't sell or close or get funded for, I don't know, 60 days maybe? Like, there's a reason why it sits in pending for a hot second. And then only then does it get funded because there's all this underwriting that has to happen. And then the funds are there. So clearly does not understand how any of that shit works.
No. Well, she's just looking for a money grab.
Fiduciaries may not retain exclusive possession of estate assets for more than a decade while denying a beneficiary inventory access and delivery. This is really not a delay. It is a failure to perform a required act of administration.
She talks slow.
My mother had moved into assisted living approximately 1 year before her death. And from that point forward and continuing after her death in November 2011, the co-trustees allowed her home to remain unoccupied, unrented, and unsold until it was finally sold at my request in the spring of 2023. That was more than 12 years during which the estate's primary asset produced no income for the beneficiaries. That is especially significant because my mother...
It doesn't have to produce income.
Well, it does for her because she wants to suck off of it.
Well, right. And it's very telling that she's talking about like taking out a loan, like using the trust or that asset, you know.
That's what I'm trying to find. I think we're there. Because that's telling. That's telling.
Very, very.
Will expressly authorize the personal representatives to sell or lease the property immediately upon her death. Despite that, the co-trustees did neither. Instead, unbeknownst to me, Mr. Naylor and Dr. Gunn transferred title into their own names very soon after my mother's death, excluding me entirely. I was never informed of this, and I only learned about it years later, in fact, just a few years ago, when I applied for a loan and listed my interest in my mother's home as collateral.
When I applied for a loan and listed my... Does that not sound like shady shit to you?
Nope. That's just that's not that. No. Nope.
We're using something we are not entitled to as collateral to get a loan.
Yeah. No, that's not a, you can't do that.
Oh, Big Tiff is going to have a field day with this.
I hope
Tiff, I'm so excited for you to talk about this.
Yep.
I think tomorrow.
Do it, please. Please.
Because this sounds shady as shit. This sounds shady as shit.
Why would you need a loan? Why do you need to take out a loan against?
Because the whole families are they're a bunch of broke ass bitches. They're pretending to be rich and wealthy, and they don't have any of it. That's what this is, in my opinion.
Yeah.
We're going to pretend we're San Francisco elite, but we're really not making the money. But we're going to run ourselves into chapter red for decades.
Super red.
And we're going to pretend by taking out loan after loan after loan. And what sounds like, to me, and again, this is my opinion, what sounds like financial fraud. But I'll leave specific analysis of that to Big Tiff, because Tiff is finances.
Yeah,
but this sounds shady to me.
Shit. Yo, it's shady as fuck. Like, again, like I don't like, even with my dad's estate and all of that and grandpa's estate, like, there was never any sort of like a application for loan to use the trust. That wasn't necessary. Like, he just had to talk to the trust administrator. Like, that's all it was.
This also reveals that they are aware of their financial status, where they cannot rely on their own financial standing to get a loan.
Oh my God.
Where we have to offload it to, we've got to go use mama's trust to try and get a loan because mommy and daddy can't get nothing with anybody else. So we're going to have to do a little financial Harry-Carry, I guess. That's what I'm hearing.
Sure.
And again, I don't practice in law. I don't practice in finances. These are just my opinions. But it sure sounds like shady shit to me.
Common sense. You practice in common sense.
Fair enough.
And this, like,
this doesn't sound like common sense.
No,
this sounds like an attempt to pull a fast one over a loan provider.
This sounds like a fucking scam.
It does. That's what it sounds like.
Yeah.
And we're entitled to our opinions. Wow. I think we have an admission here. I wonder if this ever got back to the bank, the Chapter 13 they were trying to file. If any of this entered into that.
If there's
Boy,
any
it may be a
just
really
energy
bad
in the
thing.
universe, that would be a thing.
It may be a really bad thing that the federal government is involved in Laura's, because guess where it's going to start looking?
Oh,
It's going to start looking at this lady and daddy over here.
Because the onion is going to peel apart.
The onion is getting peeled, and it's going to get sliced and diced. It's going to get sliced and diced, and I wonder if the IRS is going to enter this picture too.
Oh, IRS enters the chat. That would be amazing.
DOJ and IRS in the chat together. I think I would lose it.
I mean,
I don't think I have enough money to buy that kind of popcorn.
I'm not a big fan of the current, federal government structure and things that are going on right now. But if it's anything like this current DOJ lawyer that's filing all this stuff and like taking down David the dipshit, bring in the IRS. Let's go. Let's find an agent there and let's just tear the shit.
I mean, I see avenues for which they're all going down on the same ship. I see avenues for that. I don't want to lay all my cards out on the table, but I see some possibilities there.
Yeah.
Let's keep going. Let's see what else she reveals.
Yeah.
Loose lips.
Let's do the 175.
Like Judge Judy says, how do I know you're lying? When your lips are moving. And Jan Elizabeth Owen's lips are moving quite a lot here.
Yep.
Just like her daughters.
Play the
like
wheel
mother, like daughter.
Enjoy my background. I will be right back on camera.
Okay, fine. We'll listen to some.
I was shocked when the lender told me there was no county record of my ownership interest, only that of Mr. Naylor and Dr. Gunn. During this entire period, they did not give me a key to the home. I did not have access. I could not safeguard the property in it, and I had no ability to participate in any discussions affecting it. Probate cannot be considered complete when the estate's primary asset was left idle for more than a decade without oversight or distribution. This non-judicial settlement agreement that was spoken with, let me address that. In 2022, after more than a decade without transparency, accounting, or distribution, I was in urgent financial distress. Dr. Gunn offered me a personal loan, but conditioned that loan on my signing a non-judicial settlement agreement.
We talk about the loans.
Him and Mr. Naylor from further accountability. The loan carried interest and was secured against my inheritance. This occurred in the context of the trust's spendthrift provision, which prohibited me from assigning, pledging, or encumbering my beneficial interest. As a result, I could not independently use my inheritance to obtain financing while the co-trustees retained exclusive control over the assets and the timing of any distribution. Your Honor, the trust prohibited me from pledging my interest, yet Dr. Gunn, acting as a co-trustee, conditioned a loan on repayment from my undistributed inheritance and used his control over distribution as leverage. In substance, that conduct defeats the purpose of the spendthrift provision and is precisely why court review is necessary. In practice, this meant that the spendthrift provision operated not as a protection, but as a tool of leverage. I was financially constrained, unable to access or use my inheritance, while the co-trustees controlled both the assets and the information. Under those circumstances, the choice presented to me with regard to signing this document was no real choice at all. The agreement lacked full disclosure, pages were missing, inventories were incomplete, valuations were unclear. I was asked to release the fiduciaries from any accountability without being provided the basic information necessary to make an informed decision. Under New Mexico law, a non-judicial settlement agreement obtained under such conditions cannot shield the fiduciaries from court review of incomplete administration, undisclosed assets, or breaches of fiduciary duty. At the same time, Mr. Naylor and Dr. Gunn asserted that I owed them reimbursement for costs incurred while they exclusively controlled the property over the course of, as I say, 12 years. They claimed I owed approximately $28,000 in property taxes, approximately $15,000 in homeowners insurance premiums, maintenance and carrying costs presented later as aggregate figures without exact itemizations, and alleged advances by Dr. Gunn, initially stated as approximately $72,000, later increased to $85,000 without full bank records, tax records, or a court-approved accounting. Again, I did not have title, possession, or access during most of the period for which these costs were incurred. I was not provided with the bills as they arose, was not consulted about the expenses, and had no ability to mitigate them. These amounts were treated as personal debts to be deducted from my inheritance before I ever received it, despite the trust requiring distribution outright upon my mother's death and free of trust. The fiduciaries cannot convert estate carrying costs into personal loans secured by a beneficiary's inheritance without notice, consent, documentation, and court review. Your Honor, probate required acts of administration that were never performed. These personal assets were never distributed. Again, I do not dispute the fact that bank accounts and brokerage accounts were distributed. I'm talking solely here about the personal assets. The fiduciary duties were breached, information was withheld from me, and oversight was avoided for years. These are precisely the circumstances in which probate courts reopen estates. So I'm asking the court to reopen probate, to compel a full fiduciary accounting, to require transparency and disclosure.
She's nuts.
And to allow judicial oversight of this estate that was never properly completed. Again, Your Honor, when we ask for tax records, when we ask what the estate's EIN number was, we have never been given that. We've never been given the tax records. The list of personal property items was bare bones that their so-called appraiser had come up with on the day my mother died. Very limited descriptions, such as a picture of roses or something like that. Nothing to indicate that this was something from the 1700s, and nothing to indicate what its value in truth might have been. It just is ridiculous. And then in a couple of years ago, this same inventory was presented to me again, and at this time they had made notations about, that my mother had wanted such and such an item to go to my brother, all these different things. Coincidentally, the things that were the most valuable items of antiques and artwork, at that point they said, she'd wanted them to go to him, when in reality those things were never delineated on the initial inventory that was presented to the court. So, Your Honor, the other thing, they are asking this court to award them attorney's fees, and this request is neither equitable nor supported by law. I did not file this petition frivolously. I filed it because probate was never properly completed, assets remain undistributed, required accountings were never provided, and no court has ever reviewed these issues. Courts do not award attorney's fees to fiduciaries for resisting accountability, particularly when their own conduct created the need for this judicial intervention. If they had done what was expected of them, and what I'm sure my mother expected when she died, that the home would be sold immediately or rented, that income would be gotten from that if it was rented, and the income that was missed over the years because they simply let it sit unoccupied was a conservative estimate, $183,000. So, this estate appears settled on paper because probate was closed administratively in February of 2018, but it was never settled in reality. Again, these assets weren't distributed. The information was withheld. And my mother's clear wishes were not honored.
I didn't get what I wanted. I didn't get my entitlements.
Or come up with some other kind of a solution, whether it would be mediation or arbitration, something like that, so that her estate can finally be administered under judicial supervision, so that the personal property, the antiques, the artwork that she and my father had intended for me to have at some point could be distributed to me. And as I say, I have...
They had entitled me to have everything. Anything of value was to be for me.
They refused to tell me where these things are. And they did say that some of the things are in their own home, that some of the artwork and antiques and things are in their own home, but I certainly have had no access to them. And as I say, they're wanting me to pay storage costs of I think $315 or $350 a month, but they refuse to tell me where this storage unit is. I mean, it really stinks.
Oh, it stinks.
Thank you very much, Ms. Naylor Owens. I have a couple of questions based upon what Mr. Aufrichtig has stated about the assets in the probate estate. The motion is made primarily stating that, I'm paraphrasing, so don't hold me to this, Mr. Aufrichtig, but it's my understanding of the motion. Basically, it says, look, Judge, there's nothing left in the probate estate. All the assets that were in the probate estate have been transferred to the trust. If Ms. Naylor Owens has any complaints, and she does, we just heard what they are, those complaints are with the trustees of the trust, which may or may not be allowed to be pursued under the laws of the state of New Mexico. We're not going to talk about that in the motion, Mr. Aufrichtig is saying, because that is a separate issue that should not be raised in a probate estate. That's how I understand the motion. And so the starting point for me is to determine, as I asked Mr. Aufrichtig earlier, what is left in the probate estate that needs to be done or undone and unwound. Because as I hear you talking today, Ms. Naylor Owens, it sounds to me like your complaints, your claims, whatever they might be, you talked about fiduciary duties of trustees, that those lie with the trustee, or lie against, against the trustees of the trust, but because all of the assets have been delivered to the trust, there's nothing left for the court to do within the probate estate itself. What am I missing from your perspective in that regard, Ms. Naylor Owens?
Well, I think it's what I'm missing. You know, these were items that they were supposed to distribute to me. There is so much that they were supposed to have done over the years with regard to this estate, from filing taxes, from again getting an EIN.
Right, and let me interrupt you. It's hard to do over Zoom, so I apologize.
Yeah,
but I want to keep this moving.
Worries.
But because it seems to me what you're saying is that those actions didn't happen on behalf of the trust by the trustees. And let me use this example. We have a will here. The will says all the assets should be delivered to a trust. The will does not say, for example, deliver some amount of property, whatever it might be. Let's just call it property 1, 2, and 3, just because it's easier. Deliver property 1, 2, and 3 to Ms. Naylor Owens, and deliver the rest of the property 4 through 100 and whatever to my trust. If that were the case, then I could have some jurisdiction as the judge in the probate matter to ask the personal representative of the estate, why haven't you fulfilled your obligations under the probate code to deliver property 1, 2, and 3 to Ms. Naylor Owens as provided for in the will? But here, because all of the property goes first to the trust, there's nothing, I don't see that there's anything left for the judge to do in a probate matter because there's nothing left to be done with respect to the assets. All of these assets went to the trust. Now, they may be sitting there in a storage unit that you do not know where it is, being charged $300 and some a month to maintain, but the trustees are doing that now, not the probate estate personal representatives. And the reason that matters, it matters for a couple of reasons. First, the probate matters are governed by one set of laws, the probate code primarily. Trust matters are governed by the Uniform Trust Code, among others. And my jurisdiction over particular parties is governed by the rules of civil procedure for the district courts. And in probate matters, where we start to have squabbles between and among beneficiaries, those can be brought, but the rules of civil procedure regarding jurisdiction and notice and service all must be adhered to. And I will tell you, I only allow those in very specific circumstances where it appears that the resolution of that action is going to impact the probate estate. One of the beneficiaries, for example, is saying, I want to disinherit another beneficiary. Well, that's going to impact the estate, right, and who gets what. So I allow those as ancillary actions in probate matters when there's something left to be done. But here I don't see that there's anything left to be done. And now I'll cut to the chase. That's not actually true because I've been talking for a while, but it is that it sounds to me like your claims, whatever they are really a standalone civil action against the trustees for breach of fiduciary duty. Those are the words you've used, and that they don't have anything to do with the probate matter. And that's how I see it. But again, I welcome your side of this dispute so I can be fully informed, please.
But it doesn't appear that probate was followed.
What didn't get done?
Well, as I say, they should have done, very simple things like, filing taxes, showing where the money went, showing,
where are your taxes, madam? Where's your money gone? Let's
every accusation might be a confession. Maybe
it could be.
I don't know. Maybe.
I mean, this is why they got their Chapter 13 kicked. We couldn't even produce our own taxes. I wonder why.
Funny that.
That my understanding is that they should have done, and that my brother should have done as the personal representative, these things were not handled correctly. They did not follow what what should have been done with first of all, with regard to the house itself, that it was supposed to be, that they transferred title to themselves.
Your Honor, I don't mean to interject, but that's just untrue. That title was transferred to our clients, to my clients themselves. That title was put in the name of the trust for the residents. I just want to clarify that because that's
their names were what was on there. My name was not on there at all, and I was told this by numerous lenders that I applied for.
Well, hang on a second. Let me interrupt. I'm not here to have a trial about what happened to them.
Numerous lenders that I applied for.
Wow. Okay. Yeah.
I think I need to rewind that.
House. I'm not going to do that today. It would be procedurally improper.
Now my buttons are
working. I was told this by numerous lenders that I applied for.
Well, hang on a second.
themselves. That title was put in the name of the trust for the residents. I just want to clarify that because that's
their names were what was on there. My name was not on there at all, and I was told this by numerous lenders that I applied for.
Well, hang on a second.
There we go.
Let me interrupt. I'm not here to have a trial about what happened to the house. I'm not going to do that today. It would be procedurally improper, and it would also be probably outside the scope of the pleadings as they exist right now. So I'm not going to, I don't need to know what happened to the house. What I need to know is why you want to reopen the probate estate, because you think that someone needs to file taxes. Okay, I heard you on that. What else do the personal representatives of the probate estate need to do that you believe was not done?
They did nothing with regard to an accounting of nothing was followed.
They didn't prove to me that I got everything that I'm entitled to.
They allowed the place to sit unoccupied for years, and I had absolutely no ability
Ms. Wings, I probably should
challenge this.
And what are you going to challenge? That's my question. You've told me you're not going to challenge the will. You've told me that you're not going to challenge the trust. So if the will says, hang on a second, if the will says all of the property goes to the trust, how are you what are you challenging in the probate matter? How are you stepping in to challenge what? There's property that hasn't been transferred to the trust that you believe needs to be?
There's property that hasn't been transferred to me that needs to be.
From the trust?
Wow.
Yes.
Okay. That's a trust dispute, right? Not a will dispute.
So, just so that I can be clear, is it your view that they handled probate exactly the way it needed to be handled?
No, I don't make those determinations. I ask you what you say needed to be done. So far, you have told me they needed to file taxes.
They needed to have an EIN number. They needed to administer the estate properly, and not to take assets for their own personal use.
So you have a claim that somebody, as a personal representative, transferred assets to somebody that shouldn't have gotten it? Is that what your claim is?
Well, I'm saying I don't know where those assets are. I'm saying the personal representative, who was my brother,
she's alleging
refuses to tell me where those assets are, and yet wants me to pay storage costs for those when I have no idea where they are. I don't want them in storage. I should have been given them when my mother died.
Okay. So you want taxes, you want an EIN, you've said, you want an accounting of what was distributed from the estate. What else?
They also, there are some unusual things that happened with regard to the home being ransacked at one point when I finally had said to my brother and Dr. Gunn, hey, I really could use the proceeds from this. And at that point, then I was told that the home had been ransacked, and they sent me pictures of things just looked like animals had gone through everything in my mother's bedroom and thrown things all around. And it was an incredibly upsetting scene to see everything on the floor. It was so that it looked as though you couldn't even walk in the place. And they told me that the place had been ransacked. And yet I've had body cam video from the police who went to investigate this alleged ransacking. And
we have body cam video ourselves?
Works of art, valuable works of art from the 1700s and 1800s that my parents had. In this same scene where items are strewn all around the floor, you see in the living room of the home, there are artwork boxes, cardboard boxes, and packing materials under the works of art to be packed up and taken out of the home. So it is strange that the place was ransacked, and yet the folks who did that brought boxes to cart the artwork away and pack it up nicely. I don't know what happened. I wasn't told about this in any kind of a timely manner at all. And so, like I say, there are some things that I would like answered. I'd also like to know, I was told when I asked about, well, if there were things taken, if there was artwork taken, can we, file for an insurance claim? And I was told, no, that for whatever the reason, they didn't want to file for an insurance claim, and yet they've wanted me to pay for the cost of insuring the place over the years, and yet when there was a theft, they are not interested in filing an insurance claim. I mean, there are just some very strange things. And as I say, Your Honor, I had completely trusted my brother and completely trusted Dr. Gunn for all of these years until it really became very suspicious to me that they wanted me to waive an accounting of these things. And the more I thought about it, the more I thought this just, things are not right in this.
Okay. Why, Ms. Naylor-Owens, is this Exhibit A, Statement of Final Accounting, that is attached to this non-judicial settlement agreement? Why is that not enough to satisfy the accounting provisions of the probate code for you?
I don't have that with me right now. Is that the inventory that they had?
It says Exhibit A, Statement of Final Accounting, and it's 12 pages long. It goes through the inventory. It says value of the estate on death, and it's got a bunch of rooms, front hall, den, kitchen, master bedroom, etc., and it arrives at a final value for the amount. Why is that not a sufficient accounting for you of the probate estate?
Well, because if you look at that, it is, again, a very bare bones list of things. These were valuable pieces of art and antique furniture. And when you look at what they presented there, it would be like saying a picture of a woman with a faint smile and describing that as the Mona Lisa. I mean, you can't put any context to it. And
wow.
Does she think her parents were sitting on stuff as valuable as a Mona Lisa? Does she really?
Okay. So having gone through...
There's a Rembrandt in the back room. It was hanging above the toilet.
So having gone through 2 estates, I can tell you that people think that their shit is worth way more than it actually is.
Clearly.
And I mean, anyone tuning in, go to your local estate store or antique shop or anything like that. Just look at those, look at the wares that are there and the prices that people are asking for said wares. It's not worth what they think it's worth. I have seen plenty of pianos that I have shopped for over the course of a decade, and people think that it's worth, X amount, and it's laughable, absolutely comical what they think that shit's worth. You can't apply a sentimental value or what you feel that it's worth because it was part of your childhood or whatever. That doesn't work. It doesn't.
They have valuable pieces of art from the 1700s and 1800s, I promise.
It doesn't work. It doesn't work like that, honey.
Yet we were living in a modest house in Albuquerque, and we're claiming to have valuable pieces of art just laying around.
No.
She's nuts.
Absolutely full of it.
They said that they have photographs of these items. Under my understanding, they were supposed to have photographs of these things and photographs, therefore, of things that were stolen. And yet they have produced no photographs of these, so that in order to get an actual fair accounting of what was in the estate, you really need to have more of a detailed appraisal than that. I mean, that really is not very helpful. And they told the police that they had photographs of these things, and yet I'd like to have the photographs so that we can submit those to a real appraiser and really get a market value on those things. I do have a video that my father did with me in, I believe it was 1988, and my father and I were walking through the home, and he was explaining to me on a lot of the items what they were, because he wanted that done for estate purposes. He had explained what the items were and where they were, the years that they were from, and that
Shut
kind of
up.
thing.
Let me interrupt you
Oh
again.
my
just to keep
God.
things moving. I apologize. I'm looking at this non-judicial settlement agreement effective April 15, 2022. It's Exhibit A to the motion to dismiss probate on page 5, and this is specifically referring to that statement of final accounting that I was just referring to. It says, each of the undersigned hereby acknowledges that he, she, or it has reviewed the attached exhibits. That statement of final accounting is one of those exhibits. And agrees that the exhibits show an accounting of all transactions involving the assets of the estate and of the 2011 trust. That said exhibits are accepted as a complete and full summary accounting of all transactions within the estate and the 2011 trust. Each party approves of said accounting and distribution. And you signed this agreement, isn't that right?
Correct. And as I stated earlier, I was under a certain amount of duress to sign that. And as when I signed that, I was fully trusting that my brother and Dr. Gunn would distribute the assets that they hadn't distributed up until that point. I trusted that they would, and they didn't. They still haven't. And you know, as I say, I hired an attorney for $5,000, and the attorney went back and forth with their attorneys over the years, and they will not tell me where these things are. And you know, as I say, then they came up with a
That's
list,
right, Jen. She forgot to say she signed it under duress.
Where they were delineating who, you know, oh, my mother had said that this should go to my brother and all this kind of stuff. And it's odd that that wasn't at all included in anything that they presented to the court or that my mother had spelled out in her will years earlier. She trusted my brother to split everything fairly. That's all I'm asking, is for a fair distribution. And it hasn't happened up until this time. It needs to happen. And
I'm a broke ass bitch and I need my money.
Mediation or arbitration, something like that. And we were stonewalled. So I come to the court to try to get some sort of reconciliation on this.
Okay. All right. Thank you very much. My last question. So you told me that you want the probate estate to file taxes. You don't believe that has happened. I'll talk to Mr. Offertig here in a second about that. You said you wanted an accounting that was more detailed than what was provided in the non-judicial settlement agreement. Was there anything else you wanted the probate estate to do? I know you talked about distribution. I believe that is now a trust issue, but you've mentioned those things. Is there anything else that you're asking that for the probate personal representative to do?
Well, I'd like an accurate appraisal. And I do not feel under any circumstances that
no one cares about your feelings.
Accountable for costs that were incurred because the personal representative did not do his job in distributing these things more than 14 years ago. I shouldn't be paying for storage costs on you know, when I don't even know where the stuff is. I shouldn't have paid for insurance, although it seems they had the insurance listed under the name Elizabeth Naylor, which would be my name, which was also my mother's name, and it was insured for years, I believe, under the name of Elizabeth Naylor. So if it was insured under my name, that was improper because it was improper because my name wasn't on the title.
What?
And
what sort of bullshit logic are you trying to fucking pull right now?
That doesn't make
the same thing of how Laura has allegedly been attacked under a P. Diddy subplot with Gilgo Beach.
Oh my God.
These people are psychotic.
What the fuck is wrong with her brain?
I think it's genetic, whatever it is.
Ugh.
That's my opinion.
Sames.
I almost want to go back, but I probably shouldn't.
A whole lot of
no, please,
sense to me. And then when a theft occurred, they're telling me, oh, we can't file an insurance claim. And I think they had said that I think they said that the insurance deductible, they didn't want to file an insurance claim because the insurance deductible wouldn't be met. And yet I believe they claimed that there were 5 or 6 paintings, again, from the 1700s and the 1800s that were stolen, and that wouldn't meet the deductible.
They're priceless.
$500
priceless antiques. I just know they are.
Okay.
I feel it they are. It's my feelings that they're priceless.
Your presentation today. Thank you. Let's turn back to Mr. Offertig on those issues concerning EIN for the estate, filing taxes, those other administrative issues. Happy to hear from you on whether those have been done or have not been done and what's going on there. Please. Thank you.
Thank you, Your Honor. And I might defer a little bit to Mr. Thomas on this background, just because I was about 15 years old in 2011. Don't really know what was going on. But
Mr. Thomas, I just want to know if the estate has filed its final tax return. That's really what I need to know.
May I speak to that, Your Honor?
Please, Mr. Thomas.
Frankly, yes. However, there was no tax due either from an income point of view because of expenses and deductions that they had. And the personal representative and the co-trustees were advised as much by a CPA. Secondly, the appraisal that is reflected not only in the inventory filed with the court, with the footnote that all of this was provided for information only in as much as the assets were in the trust, and the appraisal, same numbers appear in the trust, were the result of an appraisal. I think that it's a classic exaggeration, malicious, on the part of Mrs. Owens to suggest that was all done on the day that her mother died. She overlooks the simple fact that for tax purposes, step up in basis and estate tax returns if one is necessary, all of those assets have to be appraised as of date of death. So in answer to your question, yes, the estate and trust have an EIN, filed the tax returns as required by law, and the accountings are complete with appraised values as of the decedent's date of death, not the date of the appraisal.
Okay. Thank you very much, Mr. Thomas. Thank you, Mr. Offertig. And I'm looking at the September 20, 2012 inventory and appraisal. It appears to be the same, or primarily the same, if not identical to the one that is attached as Exhibit A to the, substantially the same, the one that's attached as Exhibit A to the non-judicial
Yes,
settlement.
that's correct, Your Honor.
Okay. All right. Thank you very much. Then I don't really have any further questions. Let me tell you how I see this. I see my job here as the judge presiding over the probate matter as one that is fairly limited in scope. My job is to determine whether there are disputes as to whether the personal representative of the probate estate, not the trustees of the trust, but the personal representatives of the probate estate, have fulfilled their obligations under the probate code in an informal probate proceeding that did not have a supervised administration. Ms. Naylor Owens today has raised issues concerning the filing of the taxes and getting an employee identification number along with an accounting and some appraisal and distributions. Let me go through those one at a time. With respect to the accounting, that's probably the one that is the most significant, at least from my perspective as the judge presiding over the probate matter. The accounting that is provided both on September 20th of 2012 with the inventory, and then that's really the inventory, and then the accounting that is listed in the exhibits A, B, and C. I think there's a C that show how the assets of the estate will be distributed. Maybe it's just A and B, exhibits A and B of that non-judicial settlement agreement. Those are sufficient to satisfy the requirements of the probate code, meaning with respect to the personal representative's obligation to provide an inventory and an accounting of distributions. And I believe the evidence shows at this point that Ms. Naylor was made aware of those, both back in 2012, but then again upon the signing of this non-judicial settlement agreement. And I say specifically was made aware of because Ms. Naylor Owens has raised an issue concerning whether she is bound by that settlement agreement or not in light of her claimed issues of distress. And I'm not making any findings of fact or conclusions of law with respect to that issue because it does not affect the probate estate. And so I'm simply concluding that the inventory and the accounting that are attached to the non-judicial settlement agreement are sufficient to satisfy the personal representative's obligation under the probate code in that regard, or in those regards, I should say. So that's number one. Number two, with respect to the tax return and the EIN, I'm going to accept Mr. Thomas's representation as an officer of the court today that those taxes have been filed on behalf of the estate. The estate, when was the estate closed, Mr. Thomas? Let's start there. The estate, not the trust.
Technically, the estate was closed by Judge Bacon, now Justice Bacon, administratively on or about February 2 of 2018.
Yeah, exactly 8 years ago today. Isn't that ironic?
That's right.
Okay, so issues concerning taxes and performance of those obligations as personal representative, frankly, the time has expired for those. Those issues are gone. With respect to the administration of the estate, this court does not need to get involved in those issues concerning the sufficiency of final tax documents, given Mr. Thomas's representation here and the fact that the estate was closed 8 years ago. I'm not going to reopen the probate estate to comb through tax returns to see whether they were sufficient or not on behalf of the probate estate. So I'm going to overrule that objection raised by Ms. Naylor Owens today. And you can't file taxes without some sort of tax identification number, so I'm going to overrule that objection as well. What that leaves us with then is Ms. Naylor Owens' complaints against the trustees of the trust. Her fiduciary duty claims, I'll call them that. We've heard a lot about those allegations today. Of course, this court is not making any factual findings about the truth or falsity of those allegations. I just needed to hear what Ms. Naylor Owens' claims would be so that I can determine whether we should reopen this probate estate or not. And I'm concluding that there's no reason at all to reopen the probate estate. So what I'm going to do is I'm going to grant the motion to dismiss because it's dismissing this ancillary action that Ms. Naylor Owens wants to file. But because I'm not making any findings or conclusions with respect to the legal sufficiency of that petition, I'm dismissing the petition and again closing this estate without prejudice to Ms. Naylor Owens raising those claims in another lawsuit should she choose to do so. And those claims being, to be very clear.
She'll try.
Hang on one second.
I think.
The claims that are raised in Ms. Naylor Owens' March 24, 2025 petition to reopen probate, compel distribution of estate assets, and order final accounting. The only issue there that's germane to the probate estate, as opposed to the trust, is the final accounting, and I've concluded here that that issue has been addressed satisfactorily under the probate code. So the motion to dismiss will be granted. This probate matter is closed. Ms. Naylor Owens, whatever rights you may or may not have had to pursue the claims that you've made in your petition on March 24, 2025 are not being adjudicated by this court in any respect. So that is what the dismissal without prejudice means. It means you'll have to undertake to file a separate legal action should you choose to do so in accordance with the laws of the state of New Mexico or whatever laws govern the trust and the rules of civil procedure for the district courts. Okay. Having said that, I'm going to ask if there's any questions I can answer or do my best to. We'll start with Mr. Offertig and then we'll turn to Ms. Naylor Owens. Please, Mr. Offertig, any questions?
Your Honor, I was just wondering if your ruling did include a determination about the respondent's request for attorney's fees.
I'm not going to grant attorney's fees to anybody for one primary reason. You're going to argue if you continue these disputes, you will be arguing a lot about who should pay for what. You can simply roll this over into those arguments because all of this had to do with the trust. I mean, I think, yeah, I'm just going to stop there. I just don't think it's worth it. Okay, thank you, Mr. Offertig. What else?
Nothing else. Thank you, Your Honor. Would you like me to prepare to proposed order?
I will take care of it that way. You all don't have to worry about it. I'll do it this afternoon. I'll get the order entered. If anybody disagrees with the order or believes that it leaves matters that need to be adjudicated, you're certainly welcome under Rule 58, I believe it is, and Local Rule 2. What is the rule? I don't remember the local rule, but there's a local rule as well that you can submit to me a proposed order if you'd like, okay?
Your Honor, a quick question on procedure. There is before you that separate petition for court approval for the withdrawal of me as counsel and the substitution in my place of the Summer Law Firm. I take it with the dismissal based on your order that that's rendered moot, but for clarity, it would be appreciated if the order simply stated words to that effect.
Okay. I think that's fair. I believe that is correct. The substitution motion is moot. If it weren't, I would grant it. I regularly grant those when folks need to change counsel. So I don't see any reason that wouldn't be granted. But for our purposes, procedurally, it's simply denied as moot because this case is closed and the representation of folks, at least within the context of this probate matter, as it exists in this court, you all can handle with your respective clients.
It's over. Okay.
Okay.
Thank you, Your Honor.
Thank you. Ms. Naylor Owens, please, any questions that I can do my best to try to answer?
Yes, given the fact that Mr. Thomas says that there were tax returns filed, would it be possible for me to get copies of those since I was not given them over the last 14 years?
I'm not sure I can answer that question. You're going to have to first raise that with Mr. Ofrichtig and then with Mr. Thomas.
Because I should have been entitled to those, correct?
Well, you don't get to cross-examine me, Ms. Naylor Owens, unfortunately.
No, Your Honor, I'm asking.
Sit down, bitch.
You know, I'm asking because it was my understanding that I was entitled to those things.
Well, it depends.
Copies of the taxes.
I'll just leave it like this. It depends on who is entitled to information under the probate estate. And I'm going to leave that to Mr. Ofrichtig and Mr. Thomas to determine. I think it would make sense that you would get those tax returns, but it may not be a legal right that you have, and I don't know the answer to that question. As it sits here today, it's not properly before me with respect to the party, so I'm going to ask you all to confer on that. Again, I don't know to what end. I mean, the estate's been closed. If it has anything to do with the trust, I suppose you can ask as a beneficiary of the trustee, but I don't even know that. So I don't know is the short answer, Ms. Naylor Owens. So I can't answer that one. I apologize, but if you have any others, I can at least entertain them and let you know if I can.
With regard to, again, photos of the things that they said to the court that they filed the inventory list, but they have failed to include with the inventory list photos of what was included in the inventory, and there's no way you can order them to do that, even though they claim that they have them.
Yeah, I'm not going to order them to file photos of the inventory because it's all been distributed to the trust.
I'm surprised she's not crying and having a hissy fit.
As my understanding is the beneficiary of the trust, you can ask Mr. Ofrichtig what you
almost
are,
there
as counsel for the trustees as to what you can and cannot get if it exists. So I'm not going to order them to deliver any photos, no.
Okay. Will your order also include the fact that you're not ordering attorney's fees?
Sure. Yeah, I can include that. Yeah. I will include that.
Yeah.
Happy to.
Bury yourself further, dumb bitch.
What about with regard to the other items that they are wanting me to pay with regard to insurance and things like that over the years, taxes and, things like that?
I see those as disputes between a beneficiary of a trust and the trust and or trustee. So I'm not going to weigh in on those. Those are all parts of your claims that you may continue to pursue under the law and our procedures should you choose to do so. But I'm not going to weigh in on those today.
Okay. And where would be the proper
She's
place
giving
to take
me a
those?
headache.
I cannot give you any legal advice. I'm sorry.
Okay.
So I'm just going to have to refer you to
just like your daughter. Tell me everything I need to do so I can go get them, Judge.
Through our State Bar of New Mexico, through the University of New Mexico School of Law. But no,
okay, and there's nothing that you can do to compel them to tell me where the personal property is.
Shut up, you
where the storage unit is.
No, I'm not going to do that because those disputes, because that would require me, first of all, to have an evidentiary hearing about who said what, when, and where. And I'm not going to do that, number one, today. Number two, because that dispute is really between the trustees and the beneficiary of the trust. Once the property goes over to the trust, a different set of laws apply. So I'm not going to weigh into that today, that's for sure.
Okay.
Anything else?
Not for me. Okay. No.
All right. Well,
thank you, Your Honor.
Thank you all very much. I appreciate your time today. I will get this order entered. And again, if any of you believes I've left anything out, you certainly can file. It's probably easiest just to file a request for a presentment hearing along with the proposed order you would like to have entered if you don't think I've reached the issues that need to be reached. Okay. Thank you all very much. I wish you a very pleasant rest of your day.
Sweet Jesus.
Wow.
Sweet Jesus. She's just as conniving as her daughter, isn't she? Yeah, like I say, like mother, like daughter.
If anybody questions how far this particular acorn has fallen off the tree.
The nuts have not fallen far.
Nope.
Well, this will be exciting to see what Tiff digs out of it. This will be very interesting.
Indeed so.
Oh my God. My head hurts. Gimme, 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 gimme. It's my mommy's stuff. Gimme, gimme.
May I suggest bourbon? Because it helps.
It helps with the headaches? I don't believe you.
It numbs the pain.
Well, we aren't going much longer because my coconut is empty.
Your giant vat of I'm crossing the Sahara Desert and can't be without water.
True. I don't have a camel with a hump.
The thing that attacks me in the car when you kidnap me to go do your petty errands.
So here's my summation. The Owens women are a bunch of gold-digging bitches.
Here's my surprise face.
We're bad with our money. We run ourselves into the hole. We engage in financial hara-kiri to try and backfill what we've dug. And it's just wash, rinse, repeat.
Christ almighty.
Robin asks if she's filed against the trustees. Not yet that I know of, but I wouldn't put it past her. They're a little busy right now. Well, now that the bankruptcy's done, maybe she's got more spare time. I don't know.
Why would that ever stop them? Why would that even prevent?
Well, even they've got to take a nap once in a while, right?
I mean,
unless they're all running on Monster Energy drinks 24/7 in that household, which maybe they are.
Hey,
Someone else was doing that while allegedly pregnant. Although
God
we know she was
knows
not
what
allegedly pregnant.
God knows what they're doing there and what kind of chemicals or energy drink supplements. I don't know, whatever they're doing. Whatever TikTok thing that they saw that's like, oh, I can do the thing.
Whatever new agey TikTok thing. But I should say, maybe her daughter should have donated some of those cool sculpting sessions to mom, just as a token of goodwill. But mom isn't the face of the LLCs. I am.
Oh, I am.
It's my face that needs the Botox and the cool sculpting.
Yeah, okay.
Yeah, Jack Fox talks about the elusive comments Laura was making in reference to some of the stuff with the med spas. It's worth your watch, folks. Watch Jack Fox analyze all of the hara-kiri there. That might be my phrase for the day. Hara-kiri, is that in my book? I don't think that's in my book.
That's a good one, though.
That is a good one.
I don't know. Maybe I'm glad I'm not available on Friday for whatever other bullshit you've got going on.
It will probably be injunction stuff if anything happens in enough time.
Interact with other humans. Not that the chat is not humans, because you're all delightful humans and I love you all. But yeah, I need to get off the computer for a minute for this stuff.
Yeah. Well, the best admission was that we were trying to use an estate we didn't have access to for.
That was amazing.
Financial collateral
material. Holy crap!
That was the best part.
That was incredible.
I hope this carries over into other avenues. Because someone claimed that mommy and daddy pay for everything. Guess who's going to get hit with all the prosecution? I think the Titanic Owens is sinking. It's taking on water.
But yeah,
everything's fine. Everything's fine.
Oh my God, it's fine. Don't worry.
Let's rearrange those deck chairs by suing everybody talking about us.
Yeah, get the deck chairs moved. Yeah, whatever.
Oh my
God.
Maybe at some point we can invite the string quartet on stage to play them off as everyone else is in their lifeboats already, and they end up going down with the ship. I don't know. It doesn't sound. None of this sounds good. None of this sounds good at all. But again, I'm an idiot.
It just feels like a scam. It feels like every phishing email I've ever received in any of my email boxes ever, of like, oh, everything's a tragedy, and I need like $5,000 like rupees in India currency or whatever. And
Ron
like,
had
I'm
a
gonna be
procedure.
fine.
We need to borrow $30,000 to hold us over. I don't know. I remember there were some situations. I just don't remember the details, but it doesn't matter.
Oh, but the GoFundMe,
Sounds
don't worry
bad.
about the GoFundMe. It's not in the bankruptcy.
Yeah, the GoFundMe that was
It's
never
not,
claimed
like,
on
it's
anybody's
not- it's never
bankruptcies.
claimed. Yeah, no, that's not fine. Yeah,
The
no.
very
Don't-
unclaimed GoFundMe
Yeah, no,
and anybody's
just-
income bankruptcy stuff.
Yeah, just be quiet about
figure.
that, Echoes. Just, don't.
Go
don't.
figure.
Yeah. So stupid.
It's past my
Whatever we
bedtime.
can-
I think I better call
Whatever
this.
we can do
Let's
to keep
call
the
this. Let's
grift
just go.
going. The grift. Let's go.
They aren't
keep the
grifting
grift
enough
going.
anymore. They're in trouble. The
Andy,
engine
always
compartment
lovely
is
to see
taking
you.
on water.
It is, and a fire is about to. incur.
Once the water reaches the level of the boiler compartment, we're going to start seeing the steam before the thing sinks.
Yes. Good night, IB. Lovely to see you.
Yes.
Thank you so much for your contributions. In
Thanks,
the chat.
Thank you, everybody, for joining us on whatever weird adventure. This was weird a little bit tonight. Weird
This was
energy.
odd.
Maybe it was Mom. It kind of
She's
shifted
weird.
with Mom. I've been saying that since I started looking at
I
her.
don't fucking.
She's not playing with a full deck, and I
She's
wish
like-
we had video of her, because she sits there on other interviews when Laura's getting, and she'll just kind of sit there and chew away like she's got dementia or something. It's like there's something going on here.
She's like when you're
There's something
driving down the average street in your hometown and you see a Cybertruck driving the other direction or anywhere, and you're just like, "What the actual
What's
fuck
that
was
doing
that?"
out there? Yeah, it's like a UFO.
Why does a doorstop have 4 wheels?
And it's a doorstop. And an opening compartment and a frunk.
A frunk. What? Why? That is what
these people are not
this
normal.
Was. That's what this was. Just picture that. Every time you see a Cybertruck, you think of Jan Elizabeth, whatever the fuck her name is this week.
Jan Black, a.k.a. Elizabeth Ann Naylor Owens. Get it right.
Christ almighty. It's the same ick that I feel. I want to throw up, but I don't do that because I have halfway
It's a
nice
family
cars
of
and
ick.
And I don't barf in my car when I.
It's a family of ick whose legal troubles are only compounding with each thing they do.
Yeah.
Each thing they do. This is just bad. It's bad all around. I think we've got some admissions that could be used against them. But again, I don't practice in law, so I could just be totally farting out my mouth. I'm sure David Gingrich would agree with that, but I don't care what he thinks.
David, I think, kind of talks out of his ass anyway.
Well, he does.
Yeah.
When other seasoned attorneys are telling him he needs to get counsel and he needs to disappear and not get involved, he needs to take leave of court, but literally was what Ian Runkle said or something to that effect.
Leave of court. I love how formal that sounds.
Well, it is. Well, that's what he was requesting. So, the long and the short of was that the court was saying
court
this.
hereby orders the following. Fuck off.
That's what Jan Black was getting.
Yeah.
The court hereby orders the following. Fuck off.
Fuck off.
Although they did give her an avenue to torment her brother and husband more, but whatever.
I think maybe my
The
new
joy of being
slogan is just
trustees
gonna
with
be-
a disgruntled, nutty woman.
My new slogan, I think, for a minute is going to be, with respect, fuck off.
Oh, hi, Snow. I think you're in a different time zone. It's okay. It's past my bedtime. I need to call this. This was a late night quickie of sorts. For us, it's a quickie. Just covering a couple things.
All right.
I mean, it's not 3 hours yet, so it's a quickie as far as I'm concerned.
I've never known you to do a quickie, but maybe you should. Maybe you
This
should.
was the
You just need
itch
to,
I was
you just need
scratching
to,
this evening.
relax yourself and just go get that. And
Careful. Don't get me canceled.
I'm not gonna get you canceled. I'm gonna get you LAID.
No, we could all use that from time to time, couldn't we? A little nonsense now and then is relished by the wisest men.
Who might have cast stones out
I know.
of my very empty glass house?
You just need to collect some, valuable artwork from the trust that, is worth bazillions of dollars, evidently.
Yeah. Give me another 10 years.
Fill that glass house.
I'm gonna reopen my dad's probate, and I'm gonna reopen my grandpa's probate, and I'm gonna open.
I didn't get enough.
The hoarder
I
house
need more.
Probate. I almost said prostate, but probate, and I'd be like,
probate, not prostate, you idiot.
Yeah,
that's a Roger Rabbit reference.
Oh, that show was great. That show was fantastic. They had a band organ in that.
I know. And actually recorded it. Well, something. Maybe not that one.
They recorded something, but yeah, it wasn't maybe that one. It was. I mean, come on, it was all audio dubbed. Let's be real.
Oh, of course.
Yeah, that was.
I don't know. Might have been a real one. What do I know?
I don't know. Maybe I need to kidnap you, and we'll have a Roger Rabbit evening.
That could be fun.
Could be. We'll make some
find
arrangements.
some good popcorn.
Do
you have that on a roll? That's something you need on a roll. Merry-go-round broke down.
I probably. You know how many rolls I have left to go?
Yeah, more than you deserve.
Correct. I'm pretty sure I might have it in a box somewhere in my storage unit. But don't fuck with me too much, because that means I'm just going to make you help me go through said rolls.
No, that sounds awful. The smell of moldy paper.
Correct. So you need to treat me nice.
That would be against my health conditions that need to be protected.
Oh, shut up! You're not going to get any.
That's
official.
I'm allergic to mold. That's deadly stuff.
Whatever. Just you got to build up your immunity.
Thanks for joining us, everybody. You know what? I'm just going to get rid of him because this is going to take forever. Thanks for joining us. Thanks for this other evening of frivolity and Laura Owens and more nonsense by Mama Owens, because it sounds bad. It sounds bad what we were trying to do financially to get loans and things and try and take from the trust. That sounds like things that weren't ours so that we could try and get loans. It sounds questionable, doesn't it? But we'll wait for Big Tiff Dog's analysis when she decides to do that. I think her live is tomorrow sometime, so I'm excited to see that and see what else she says, because it sounds bad to me, and I don't know nothing. So we'll leave it to the people who do know something, and then we'll be back when there's more stuff, and we'll see how things go with the injunction hearing, which is taking place for Hey Rob on Friday. I think there have been some announcements about when and where that is. I think I've seen. Twitter's been busy today, and I've ignored half of it because a lot was going on in the last few hours. But be that as it may, thanks for joining us, and until next time. Should I bring him back one more time just to say bye?
Bye, and fuck you. Bye.